Usually the first question I ask is this a one-off or is this a relationship? If you're ordering a single piece of equipment then you're never going to talk to this guy again, you could probably do that on a 1 or 2 page contract, even a PO if the terms and conditions are reasonable. Mm-hmm. If you're establishing a relationship, then you need to give it a lot more thought.
Welcome to An Ounce of Prevention, the podcast. At our Reese & Associates, we believe that an ounce of prevention is worth a pound of cure. Our daily commitment lies in informing our clients about legal risks without hindering their business objectives. As we like to say, we're in the business of building companies and helping executives sleep at night. So stay tuned. Maybe you'll learn something that'll help your business grow and thrive.
Hi, I'm Rachel Reese. Today we're being joined by Matt Reynolds. Matt is a partner at our Reese & Associates and team leader of the commercial contracts practice area. Welcome to the podcast, Matt.
Thank you for having me.
Are you so excited?
I'm very excited.
It's going to be amazing.
Quivering.
So Matt and I are here today to discuss different types of agreements, right? But stick around afterwards for a much-loved case law update. All right, Matt, let's get started by you explaining to the audience why you're the guy to talk to about commercial contracts.
Well, first of all, I've been working with commercial contracts, specifically in and around the oil patch for about 20 years now. In that time, I've dealt with all the usual suspects, the kind of contracts that vendors and operators are working with every day. And then I've drafted more than my share of the sort of standalone, bespoke, customized to a situation type contracts, which do arise from time to time. So several states, several aspects of the industry, but I feel like I've gotten a pretty good breadth of contract coverage.
Yeah. And here you're doing them a lot. So, I mean,
Yes.
all day, every day. That's what Matt
every
does. Okay, so someone comes to you, says, I need a contract with a vendor. What's the first question you ask?
Usually the first question I ask is this a one-off or is this a relationship? If you're ordering a single piece of equipment then you're never going to talk to this guy again, you could probably do that on a 1 or 2 page contract, even a PO if the terms and conditions are reasonable. Mm-hmm. If you're establishing a relationship, then you need to give it a lot more thought. Put into place something more like a master service agreement or a similar contract that's going to govern the relationship going forward.
I imagine it's also pretty important to know what kind of vendor they are.
Yes, that's absolutely the next question, because just like with most things in life, one kind of contract is not going to cover everything. Mm-hmm. And even a master service contract, which is typically designed to be flexible and to cover a broad variety of goods and services, there are certain parts of the industry, certain types of services that it's really not the right fit. Mm-hmm. If you're only providing offsite consultancy, the master service agreement's not going to make any sense.
Yeah.
Or if you're providing software that's going to be used remotely or accessed via the cloud, an MSA is a square peg for that round hole.
Absolutely. But MSAs are the most frequent type of contract that you see in the energy industry. And so I'm sure you get this all the time. Everybody just says, well, we'll just do an MSA. Yeah. So what's different about an MSA than other types of contracts where it maybe won't be appropriate in every situation?
Because the MSA is so ubiquitous. I mean, almost every operator, if they don't have an MSA, they really need one.
And Matt can help you with that.
And I can help you with that. But MSAs are designed to cover a broad variety of potentialities and potential types of relationships. Sometimes they're a little bit too broad brushed, and that's why they get negotiated. Mm-hmm. If somebody only does rentals, they're going to want to push back and remove a lot of different portions of the MSA that might not apply to them. But generally, the reason why MSAs are different and used so frequently is they're specifically crafted to deal with the risks and responsibilities usually for field or well site work.
Yeah.
And that's a completely separate sort of indemnity scheme than you see in almost any other industry. And because of that, the MSA becomes sort of the foundational document, and then it can grow from there. And the nice thing about it, a well-drafted MSA, is that it can be modular. You can essentially bolt on the additional pieces that you need. So if someone is doing on-site, well site work, but they also might be providing offsite consulting agreements or consulting services, or providing, proprietary technology, then you might be able to address that just by adding a schedule or an addendum that has the necessary terms. And then as long as the MSA is drafted correctly and it makes reference to like when those apply, which terms will take precedence, because otherwise in a sort of standard MSA form, there might be terms that conflict with what really needs to be in place for the relationship to work.
Yeah, for sure. And that's where we come in, right?
That's right.
So you mentioned field work, being on site. Is there any instance where a contractor, company, etc., might be on site but not need an MSA?
Well, there's certainly some specialized service providers, drillers, for example.
Yeah.
If you're a drilling company, you're not using an MSA. You're using typically an IADC drilling contract, either on a day work basis or otherwise. The risk allocation is somewhat different there because it's so specialized and it's such a niche, and the risks are substantial enough that they need to be covered very carefully.
I mean, it's probably the riskiest thing that's happening in the whole life of that well, right?
Most of the time, yes. But that, and then occasionally, like I mentioned earlier, if it's a one-off, someone might be coming to the well site one time, and they might be dropping off a specialized piece of equipment, or they're coming out to do a one-time certification of a piece of equipment and on a service basis. You still need those risks to be covered off and dealt with. But as long as the written instrument between you and that service provider has the appropriate terms and conditions, then you could literally do it with a service order or a work order or just a simple letter agreement, as long as those terms and conditions are appropriate to the task.
Yeah.
And so that's why a lot of operators have their own standardized terms and conditions that go on their work orders, their purchase orders, things like that, so that you can use them outside of the scope of a master service contract or a master service agreement. But when you do have an MSA, all of those terms and conditions are out the window. They specifically don't apply. They're overridden by the MSA. That is your governing relationship document. And at that point, then the work order or the PO are simply the call out to work. And when it's accepted by the vendor, then you're on.
Attention, all you deal makers in the Houston area. Get ready for the inaugural Deal Makers Haunted Hall Gala on October 23rd at Meow Wolf Radio Tav. It's going to be a night of networking, giving back, and some spooky thrills. The Deal Makers Haunted Hall Gala is your chance to meet with industry leaders while making a real impact on the communities we serve. This event isn't just about fun, it's about giving back to those in need. We're looking for sponsors to help make this event a success. With sponsorship levels ranging from $2,000 to $5,000, every contribution goes towards supporting local communities and making a difference where it matters most. The more sponsors, the greater the impact. We need your help to make this unforgettable. Visit www.rreeselaw.com for information about events, tickets, and sponsorships. Email rlampier@rreeselaw.com to sponsor and be a part of something bigger than just an event. Let's make Halloween one to remember. Dealmakers Haunted Hall Gala, where the networking meets charity in the spookiest way possible. So tell me about CSAs.
Yes. Consulting services agreements, or just consulting agreements, they have, different flavors. And sometimes those are well site. And sometimes they need to be drafted to deal with well site and off site. And you might have a different risk or indemnity scheme that applies depending on what work they're doing.
Yeah.
So you can bifurcate. But a consulting services agreement is generally for someone who is providing advice, guidance, supervision, and not providing goods of any kind. Usually not even, a separate software suite or something like that. This is strategic guidance. This is leadership guidance. This is specialized revisiting of policies to try to make sure that the company is operating optimally. So when you're bringing on a consultant, it's as opposed to hiring them as an employee. And typically the warranties are quite different. So instead of warranting that, the goods delivered here under, shall be free of material defects, it's you are qualified and skilled and trained with requisite expertise, and any employees that are provided to perform these services are adequately supervised, and if they are professionally licensed, that the services they provide comport with the licensing requirements and the standards that are applicable to that industry.
Yeah, makes sense. So consulting, right?
Yeah, it's just for consulting.
Okay, so we covered MSAs, we covered CSAs. What are some of the other types of contracts that you see in the space?
Everything under the sun is the short answer. But what I see most often, so outside of drilling contracts, MSAs, and consulting services agreements, it's licensing agreements, software as a service agreement. And sometimes those aren't standalone. Sometimes those are, like I said, bolt-ons to an MSA or to a CSA.
Yeah.
You could have a consulting services agreement that has specific licensing terms. Or what if you're hiring a consultant to develop technology for you that you then own all the rights to? So it's a work made for hire. And something like that would be covered off in either a standalone license agreement, joint development agreement, or it can be bolted on or included within your master agreement if that's appropriate. Supply contracts, requirements contracts, distribution agreements, exclusivity agreements, and that's sort of, I'm talking like supply chain exclusivity rather than land and asset acquisition kind of exclusivity.
That's its whole other
That's
thing.
a whole different ballgame.
Yeah.
Done plenty of that too. But those are probably the ones that I see most often. Then, of course, very little happens in the oil patch without either confidentiality agreement, non-disclosure agreement, or at least relatively fulsome confidentiality terms within the body of your master agreement.
So what are some of the common misunderstandings when someone is trying to decide what type of agreement they need?
Probably the most common mistake is the one size fits all.
Yeah.
Oh, you're going to show up at my well site, so you must sign this MSA. And then specifically if they take the stance that this has worked for everyone else, you can't modify this. It's like, well, I don't do 99%, and 99% of your contract terms here don't apply to us.
Yeah.
And it's missing all the things that do apply to this. So going into the discussions and the negotiations, laying the groundwork that we are fine with the general scope of what this contract is going to cover. And that's something that your lawyer can advise you on before you have those discussions. But making sure that they know up front, there's going to be additional documentation needed.
Yeah.
If you're providing a piece of equipment that gathers data, that transmits it to a cloud-based platform that then people are going to access on their computers later, that's typically not going to be covered by your standard operator's MSA. There's a lot of pieces there that it would be completely inapplicable. And if you tried to sort of wedge those services and that series of transactions into a standard master service contract, you end up redlining more than you end up writing, when you're trying to negotiate that. Whereas it might just make more sense to have a master service agreement that specifically only applies to the on-site work and a separate agreement that applies to the licensure of the software, use of the platform, collection of data, ownership of intellectual property. Like I said, you could modularize an MSA, but you might end up with an MSA with like 19 schedules to it instead of just having an MSA and a license agreement.
Yeah. Don't want to make them any harder to read.
You don't want to make them harder to read, but probably, in a nutshell, lack of flexibility is the biggest mistake that people tend to make. Is they assume that that the agreement can be done, or that the relationship can be memorialized with a simple agreement that has worked in the past, and so therefore there must be nothing wrong with it. And there might be nothing wrong with it. It just might not apply to the situation. So right fit is important.
Yeah, completely agree. Well, any final thoughts for our listeners?
before you get into any kind of a material transaction, please talk to a lawyer, whether it's us or somebody else. I also, like you said, manage our disputes practice, and that usually comes from agreements that we didn't draft or negotiate, no one's willing to claim that they drafted, and it was negotiated without input of counsel, and good intentions and a great spirit of camaraderie at the start of things isn't going to carry you through when something goes wrong.
Oh gosh, I couldn't agree more. I don't know how many times we should just sign it. We're all friends here. We're not going to all be friends here when someone files a claim and someone's looking for who's responsible. So let's figure it out now while we're all friends instead of later on.
And sometimes it's even before a claim is filed. Sometimes as soon as someone has to actually write a check to the other person, you're no longer friends. Now you're business partners. So.
All right. Well, hey, Matt, thanks for joining me today.
No, this was great. Thank you.
If you'd like to be a guest on our show or have any questions or ideas for the podcast, please email us at podcast@rreeselaw.com. And now it's time for another case law update. Today, we are talking about the case that touches on the COPAS Form that's included in most joint operating agreements and unit operating agreements. COPAS stands for the Council of Petroleum Accountants Societies, which is a nonprofit organization that develops model accounting procedures for the oil and gas industry. Today's case is a recent ruling by the Wyoming Supreme Court called Chesapeake Exploration LLC versus Morton Production Company LLC. This case arose from a dispute over a unit operating agreement governing oil and gas development in Converse County, Wyoming. In 2008, Morton, a non-op working interest owner, entered into a JOA and then a subsequent UOA to develop several oil and gas leases with Chesapeake. The UOA used the 1985 COPAS Form to govern accounting between the parties. In this dispute, the parties focused on paragraph I-4 of the form, which states in part that all bills and statements rendered to non-operators by operator during any calendar year shall conclusively be presumed to be true and correct after 24 months following the end of such calendar year. And then it goes on to state that no adjustment favorable to operator shall be made unless it is made within that same prescribed period, so 24 months. For various reasons and on multiple occasions, Chesapeake adjusted Morton's ownership interest in a producing well, leading to significant fluctuations in Morton's financial obligations. When an operator changes its accounting after the accounting period has already passed, it's called a prior period adjustment, or PPA, and this happens very frequently in the oil and gas industry. Chesapeake also withheld Morton's share of production proceeds, asserting that Morton owed additional costs associated with the project's development, a practice commonly known as rev netting. Morton sued Chesapeake for breach of contract, violation of the Wyoming Royalty Payment Act, and conversion. Here, Morton argued that Chesapeake adjusted Morton's working interest outside of the time period set forth in paragraph I-4, and therefore breached the UOA. At the district court level, summary judgment was granted in favor of Morton. Since Wyoming does not have intermediate appellate courts, this case went straight to the Supreme Court of Wyoming. The Wyoming Supreme Court affirmed the lower court's decision, holding that Chesapeake breached the contract by invoicing Morton for costs beyond the agreed-upon 24-month limitation period, which was described in the 1985 COPAS Form. Additionally, the court held that Chesapeake violated the WRPA by withholding production payments without placing the disputed funds in escrow, as required by the statute. The 1985 COPAS Form restricts the time within which an operator can make adjustments to joint account costs, specifically to 24 months. The court ruled that the COPAS accounting procedures were unambiguous, and that adjustments to ownership interests were subject to the same time limitations as other adjustments. It's important to note that after the 1985 form, which was used by the parties in this case, the COPAS organization issued updated forms in 1995 and 2005 that clarified that ownership changes were not subject to the 24-month statute of limitations described in paragraph I-4. However, since the parties used the 1985 form and the court found that this form was unambiguous, the court did not rely on this extrinsic evidence. Additionally, the court ruled that Chesapeake violated the WRPA by failing to place the disputed funds into an escrow account. So why should you care? Well, prior period adjustments are a routine part of oil and gas accounting. They can be for a variety of things, and a change of ownership interest is one of them. So if your JOA or UOA uses a COPAS form, you should check its year and make sure that your accounting department knows how far back you are legally allowed to make these adjustments. That's all for today. Thanks for listening.
The information and material in this episode is general information about our practice and firm and is for educational and informational purposes only. This information does not offer specific legal advice, and the use of this information does not create an attorney-client relationship with RRNA or any of its attorneys. The information in this episode, or any episode of An Ounce of Prevention, should not be considered legal advice, and persons should not act upon this information without first engaging professional legal counsel.
Thank you for listening to An Ounce of Prevention, presented by R. Reese and Associates. If you found this episode informative, subscribe to, rate, and review our podcast on Spotify, Apple Podcasts, YouTube, or wherever you listen to stay up to date with future episodes, case law updates, and breaking news. If you have any questions or are interested in learning what RRNA's outsourced legal department can do for your company, reach out to us at podcast@rreeselaw.com. That's podcast@rreeselaw.com. Follow us on LinkedIn or call 832-831-2289.